All right, so I have 2:45 on the dot on my clock, so well done. Thank you to board staff. Yes, Mr. Wilson, it appeared to me that you had rectified your
Yes.
video.
Good day, my lady. The camera was working, and now it seems as if it's not working again.
All right, well, don't give up. Let me hear from the appellants, and you can work on that in the interim, hopefully, while listening to their submissions.
Thank you, milady.
Yes,
Milady, just on housekeeping, hopefully you should have the binder, which is the hearing bundle,
yes,
which is fortunate. It's fairly light reading, if I can put it that way. a few authorities. You should have obviously our submissions, to which I'm obliged to my learned friend Mr. Horseman for doing the heavy lifting.
yes, I have them and I've read them.
I'm grateful, and you should have my friend's skeleton argument.
Yes,
You should also hopefully this morning have received 2 documents, one headed good character,
yes,
and the other, I've always.
Anna Foreman-Chuck.
Thank you, Foreman-Chuck decision.
Yeah.
Thank you, lady. I do not, unless your ladyship wishes me to, I intend in my usual way to hopefully hit the high notes.
Please do. You can take the documents as read.
I'm grateful, my lady. So might I make just a sort of general observation in the outset? It's always interesting when one approaches these types of cases when you haven't been involved at first instance and you're reading the material.
Yes,
And in my respectful submission on reading this, on the whole, it struck me, I would ask your ladyship to consider this.
mhm,
The case certainly was dealt with appeared to be dealt with by the learned judge more as if it was a civil case under negligence than if it was as opposed to a criminal case.
mhm.
And I'll hopefully make those points good. But essentially what we have here is the learned senior magistrate being faced with 2 versions of events.
Yes,
And what she essentially did was to prefer one version over another.
mhm.
Respectfully, that is not the way to deal with a criminal case. The way to deal with a criminal case is to consider the defense that has been advanced. And if it is not fanciful, and I use that word quite deliberately, that's from Wilkinson, if it is not fanciful, and pausing there, I'd merely point out that the learned senior magistrate didn't hold it to be the defense to be fanciful. But assuming it is not fanciful, it is then for the prosecution to disprove, and I use that word quite deliberately, the defense that has been advanced. That hasn't happened here. What you have, and perhaps, my lady, very quickly, if you could go to page 30 of the record, that's at tab 1.
Yes, I have it.
Again, I find it useful just to have in my mind where this, I didn't even know where Pine Tree Avenue was.
I've actually looked at that, so I'm quite, quite comfortable with it.
If I can put it with though, it's that stretch of road between the marketplace, Heron Bay Marketplace and Heron's Nest.
Yes,
So that is the area that's occurred. Then if you turn to 31, you will see a photograph of the accident site.
right.
Now, if you look carefully, lady, it's not abundantly clear, but if you look underneath the van, if I can put it that way,
Mhm,
at a point where the yellow line stops,
mhm,
if I can put it this way, in the shadow of the van, you
mhm.
should see very faintly an X.
I do see it.
Grateful. That is where Mr. Francis marked where the collision took place. Now, that is important because the complainant's evidence is that she was riding in an easterly direction, so i.e. towards the van, in the middle of the eastbound lane when this accident occurred. The accident site was almost directly over the yellow line.
Mhm.
Now compare and contrast that with the appellant's evidence, which says he was going to turn into Pine Tree Avenue. A vehicle that was traveling eastward had stopped, had waved to allow him in. He began the turning, at which stage the complainant was overtaking the stopped car and collided with the van. So you have two very, very different versions of events.
Mhm.
In my respectful submission, the physical evidence, certainly as to where the collision happened on the van, supports the appellant's version of events. Secondly,
Sorry, have we lost the appellant? I don't see him on my screen.
I don't. I have four. I don't know whether they've disappeared or not. They were here.
Let me call you.
Thank you.
Mr. Horseman, can I continue?
Yeah, you continue. Well,
Thank you, Mr. Horseman. I was asking her ladyship.
sorry.
My lady, if you can then have a look in front of the van, you should see a white, which look, not that I'm an expert, but what appears to be a fresh scrape mark.
That
Right.
runs horizontally or,
Exactly, running horizontally, yes.
yes,
That is the scrape mark that is referred to
in the examination.
in the examination, yes. And ironically, well, not ironically, but importantly, that is the scrape mark that is noticeable by its absence from the learned senior magistrate's notes.
Right.
And that scrape mark ends where the bike, where that little pile of material is where the bike was left. So the scrape mark stopped where the bike ended up. Again, the only point I'm making on that, milady, is that is consistent with the appellant's version of events as opposed to the complainant's version of events. But I have to keep, because I caught myself in this trap, if I may, by saying, oh, what is more consistent with, which version is more consistent? But you have to go, if I can ask you to go to our submissions, the extract on the facts, yes, if I ask you to go to the extract on Wilkinson, it's in paragraph 32 of our submissions.
Yeah.
The relevant part, the lady we set out. So this is in relation to the defense.
Mhm.
However, if an explanation other than a fanciful explanation is given by the defendant, it is for the prosecution to disprove it. And unless it is disproved, the defendant is entitled to the benefit of the doubt.
Mhm.
So what we have here, if I would say, in fact, and respectfully submit, if this case was a civil case, in fact, even on the balance of probabilities, the appellant's version of events should be preferred. But we're not in that situation. I don't delve into criminal law. I have to keep reminding myself that it is beyond a reasonable doubt.
Mhm.
And in my respectful submission, given the physical evidence which doesn't lie, that supports the appellant's version of events.
Right.
Secondly, and in any event, you remember the evidence of Mr. Carter Stevens.
Yes.
Again, respectfully, both the learned judge and it appears the DPP, I'm not saying Mr. Wilson because these aren't his submissions, appear to have got the wrong end of the stick. Mr. Carter Stevens' evidence was put forward for two reasons. One, so that he could give the evidence that there was a lengthy conversation with Mr. Francis and the police sergeant at the scene, which Mr. Carter-Stevens supports. Just pausing there, compare and contrast that with the police sergeant's evidence that the conversation lasted about a minute, which is respectfully almost impossible to understand. Mr. Francis' evidence, as confirmed by Mr. Carter-Stevens, was that the conversation was about 10 to 15 minutes.
Mr. Joe, I have to say, that wasn't clear to me on your submission. What's the significance of the duration of the conversation? I've missed that entirely.
Well, simply because what happened was Mr. Francis then gave to the police sergeant his version of events,
Yes,
which was the vehicle having stopped, her overtaking, and this was the version that was given to the police immediately after the accident.
yes,
This wasn't something, if I can put it crudely, that he cooked up, 2 weeks later.
right. Oh, I see. Okay, so it's to disprove the recent fabrication.
There was exactly, because what we have is we have the learned judge, senior magistrate,
Mhm.
saying, I prefer her evidence over his evidence.
Okay,
And what is implicit in that is that his evidence must be completely concocted.
yes, thank you.
Well, he would have had to concoct it very, very quickly. I don't think that was ever put to him anyway. And it was done. The explanation was given to the police officer in the hearing of Mr. Carter-Stevens. And he was the one who went to the police officer and queried and asked the question, saying, well, given that she had overtaken a vehicle just immediately before the accident, how can you be prosecuting? I see your ladyship frowning and looking.
No. I'm just looking for a reference that actually may be supportive of your point. That's fine. Please continue.
Sorry, thank you. As I say, I'm trying. I could take you, if your ladyship has, I could take you to the extracts if you want me to find them.
Yes,
But
please.
just-
That's exactly what I'm looking through.
This evidence that I'm paraphrasing happened.
Mhm.
So Mr. Carter-Stevens was there,
Yes,
not to corroborate what actually happened, but to confirm the conversation that was had between Mr. Francis and the police sergeant, and to
Yes.
confirm what that, A, the length, but B, the content of that conversation.
It also says, young copy.
And just for your ladyship's note, page 28 of the record, I'm obliged to Mr. Horseman.
it's 28 of the record. Thank you.
Well, this is, in fact, my lady, the transcript, the tab two.
At tab 2.
The point I was,
Yes, no, I have that open, actually. That's where I was looking. I just couldn't.
So
find
that,
the
I think
exact
about 3/4 of the way down, about line 25,
yes, it confirmed that he saw.
he also, Mr. Carter-Stevens confirmed that he saw a car had stopped.
Wait a minute, my page 27 and 28.
28, Katie,
28 is the
line
statement of
24,
Messiah.
answer, when I got to the top of the estate, I saw my colleague's van and I observed a bike under the van. A car in the oncoming traffic had stopped. That's,
Are you at tab 2, my lady, the transcript?
I was at tab, oh, I see, no, that's what the problem is.
Ah.
My tab 228 area,
28.
this is it. Thank you,
line 20, lines 24 to 26.
thank you.
So
Yes,
Mr.
it's
Carter-Stevens, as far as direct evidence goes, is able to confirm that there was in fact a stopped car in the eastbound lane. Again, consistent with Mr. Francis's version of events.
Yes,
I'm just checking my notes, lady, as I go through this.
Mhm.
Yes, I've done well considered. Yes, I've said this is not a fanciful explanation. Yes, can I just on the point about the scrape mark, my lady, this is how my learned friends seem to deal with it in their submissions. And I think it's useful I'm going to go through them very quickly at the end of my submissions, but on this point, if you can go to their submissions at paragraph 28,
Right.
and this is a general, well, one is going to be a general observation, one is specific. If I can just read it out. At trial, the appellant presented an explanation of how the collision occurred. Defense counsel relied very heavily on the photograph which was taken at the scene of the collision. The appellant's case was a scratch, which was that the scratch, which extends from the westbound lane into the eastbound lane, proves that the complainant was overtaking in the westbound lane. However, re-examination, this is interesting, the respondent disproved this account. Well, that's just respectfully wrong, because we'll see why. When APS Butler testified that although she acknowledged there was a scratch mark in the photograph, there was in fact more than one scratch mark on the road, and she was not able to determine when the marks were made or where they came from. That is not disproving anything, lady. To put in the colloquial, that is simply saying, I don't know.
Hello?
So saying I don't know doesn't help the prosecution case, but more importantly, it doesn't disprove the defense case.
Yes.
Hello, my lady?
Mr. Wilson, we hear you, and we can see you.
Right.
Do you
Yeah.
not hear and see us?
I can, and I was just wondering if, like, I didn't want to let Mr. Deal get too far in his submission, referring to paragraph 28 of the Crown submissions.
Yes.
The Crown filed amended submissions. And so the amended submission, the paragraph 28 is much different from the one that you just read.
I haven't seen, I'm sorry.
I
I
have
haven't
not
seen.
seen any amended submissions from the Crown.
Yeah, I'm sorry, I'm going from,
My paragraph 28 is as Mr. Deal just read it.
that's all, that's the only version I have.
You can arrange with the court associate, Ms. Williams Grant. Well, what you can do is you can just send whatever submissions you want us to rely on via email, no, and then hopefully before you come to address me. someone
If it
will
can
attend
be
to it.
sent to my assistant, the lady, Miss Bailey, because obviously she needs to print them off and bring them down to us where we are.
Yes, my lady, the submissions to which I refer were sent yesterday to Miss Wendy Butterfield. And then I
Were they
sent,
sent via Supreme Court email?
no, ma'am, they were sent to Wendy Butterfield.
Well, I can recall many a times when I was a former registrar insisting that council will find themselves in hot water when you do that. You
Yes,
have
ma'am.
to send these things to Supreme Court at gov.bm. And the registrar sees it, other members of the court registry see it, and it gets to me more reliably than sending it to one individual.
Yes, ma'am, I had asked Ms. Butterfield to ensure that the judge,
That's the wrong procedure, Mr. Wilson.
yes, ma'am.
He said, ask him to send it to us.
Were they sent to us by any chance?
Yes, sir, I sent them directly to you
Oh,
yesterday evening. I can send them again.
if you could to my assistant, that would be helpful. Sorry, I didn't see them.
Yes, sir.
Thank you very much. So if I can move, while that's happening.
All right, so anyway, I've taken your point on this, on the paragraph 20 of the original submissions. Mr. Wilson will probably address me on that.
Yes,
It sounds as if,
I might ask your lady some indulgence from your ladyship to respond to these submissions in due course if there's anything new in them.
yes,
In any event, lady, if we can move on, the next point another heading, if we're using headings, would be the lack of TCI evidence.
yes,
Rather interestingly, if your ladyship can go to our page 4 of our submission, paragraph 14, bottom of page 4.
yes,
In cross-examination, Acting Sergeant Butler confirmed the existence of a scrape leading to the cycle. I know you're not a road traffic investigator, says Mr. Horstman, but you see if there's a big scrape leading to the cycle, yes. You agree with me that the scrape is on the other side of the lane that starts from it. And then the objection from Crown Counsel, I think we're getting into a TCI area. I would respectfully completely agree. This was a case that cried out for TCI evidence. If the Crown is going to be able to prove its case, TCI evidence didn't occur in this case, and the reason
I think it was between some 4 months after the accident.
well, that's all they did was show up to take measurements.
Mhm.
And the reason that they did, where is it? Submission, sorry, I'll just find it. Yes, paragraph 34 of their submissions, or the version I have, where it says the engagement of a traffic collision investigator is purely a decision for the attending police officer. Typically, TCIs are only called when there appears to be a very serious accident, where there appears to be a significant likelihood of death. Well, that's a policy decision. And if the police decide to use that policy, they can't complain when later on questions are raised as to a scrape mark, which appears to be fresh, which leads to the cycle, which starts in the westbound lane, and then say, oh, we didn't have TCI evidence by virtue of the fact that it's, we don't do it as a matter of policy. And then perhaps, well, the evidence in general of the police sergeant is of little assistance when she stated that she had approximately a 1-minute conversation with the appellant. As I said earlier, this conflicts with both the evidence of both the appellant and Mr. Carter Stevens. And she even denied having a conversation with Mr. Carter Stevens when he provided detailed evidence of it. So on an issue of pure credibility, respectfully, the police sergeant's evidence, so far as it goes, is of limited value. But for reasons unknown, because she doesn't give any, the learned senior magistrate chose to prefer the complainant's evidence over those of that of the appellant, and where relevant, Mr. Carter Stevens. And no reasons are proffered for her or by her why she did this. And completely ignored the physical evidence. Yes. And you will note, in fact, I can take you to it, but there were noted submissions from Mr. Horstman at page 32. So it's right behind the photograph.
Page 32.
32, tab 1, the lady.
Okay, thank you. Yes.
And those were, if I can take you to the decision of Mr. Justice Caverly when he was Chief Justice.
You gave some extracts on that in your written submission.
It's in the submissions, and I was merely going to, I'm not going to read it, milady.
Okay.
It's for your ladyship's note. Your ladyship can read better. I'm notoriously bad at reading out loud. At paragraphs 36 and 37, we make the point.
Okay.
But Mr. Justice Caverly in the Cabral case sets out quite clearly, and there's no doubt that there's a duty on the learned magistrate, in this case, a learned senior magistrate, to set out to give reasons.
Yes.
And I don't think there's any dispute that there's a complete dearth of reasons given by the learned senior magistrate.
Right.
And then finally, my lady, subject to any comments from my learned friend, Mr. Horstman, there is.
Sorry, 1 moment. Let me just put something for the record. Mr. Francis, I see that you keep cutting in and out. Are you fine for us to continue while you're having these apparent technical difficulties? Because you've been present most of it.
I think we're good now. We just moved to a different location.
Okay.
We should be okay.
All right. Thank you.
Fine, now, but
But if you drop, can we just continue without any interruption and wait for you to just come back and join us?
Yes.
Yeah, absolutely.
All right, thank you.
Thank you, my lady.
Mhm.
I'm sorry, I'm not paying attention to who's coming and going.
Yeah.
I'm focusing on the submissions.
That's
The
fine.
final one, my lady, is the good character submissions.
Mhm. Yeah,
That is where my learned friend's affidavit comes into play,
yes, I've seen it.
where he says quite candidly and if I may say, somewhat nobly, mea culpa, I forgot to raise the good character evidence.
Yes,
And I include, that's why I included the extract on Archbold on the good character.
Sorry.
Yes, as well as a case which I know your ladyship is familiar with, Formanchuk.
Orange.
Yes, and yes, and Bragg you've included in the number. Respectfully, I think Formanchuk helps the matter more. It's obviously not least of which it's a decision of the Court of Appeal.
Yes,
And I don't intend to read it all out.
mhm,
Pick it up for your ladyship's note, page 5, where
Yeah.
you should, I would encourage your ladyship to read it in due course, where it's
Mhm.
picked up under ground 2,
mhm.
and then goes over on the issue of good character, picking it up at halfway down page 6, the paragraph that starts, the court summarized the matter.
Yes,
The court summarized the matter and stated the principles to be applied. A direction as to the relevance of his good character to a defendant's credibility is or was to be given where he's testified or made pre-trial answers and statements. That's happened here. A direction as to relevance of his good character, the likelihood of his having committed the offense charges to be given whether or not he's testified or made pre-trial answers or statements. Where the defendant is a good character is tried jointly, with bad 1 and 2 still apply. And then going on over the page 7, I'm being as quick as I can, milady.
that's fine, thank you.
If you could pick it up in line 12, the paragraph starting, in the case before us.
Yes, I see it.
In the case before us, there was evidence from the appellant at trial that she'd not been in trouble with the police before, nor did she have any previous convictions. In those circumstances, the trial judge was obliged to give a good character direction as to credibility and propensity. He failed to give any direction at all as to the good character of the appellant. During the evidence of the appellant, her counsel attempted to lead evidence, which has in fact led, but to which the learned trial judge indicated in the presence of the jury that it was irrelevant. The evidence was clearly relevant, and counsel should not have been inhibited in any way from leading the evidence. And then importantly, the failure of the trial judge to give the good character direction amounted to a material irregularity in the trial. This is a case in which the credibility of the appellant was the forefront of our case. Similarly with us, milady.
Mhm.
We felt obliged to hold the conviction should be quashed and the sentence set aside. There may be cases where the court will not quash the conviction, where there has been a non-direction as to good character. This is not such a case. So in our case, milady, there's no question the credibility of the appellant is the forefront of the issue. And this is not a criticism of the learned magistrate, because the fault unfortunately lies with my learned friend on this, but I don't know if it would have made any difference because in relation to this, but certainly where Mr. Francis is a previous good character, the trial judge should be all the more careful in saying, in essence, I think what you've done is make up the evidence. I think you've concocted a story, because that must be the inference where she says, I prefer the complainant's evidence over the appellant's evidence.
Yes,
So in my respectful submission, even if all else fails, which is difficult to envisage given the fundamental failures of the learned senior magistrate, the fallback position is we should succeed in any event on the good character point. My lady, those are my submissions. I've just received my learned friends, so perhaps we could hear from him, and I will have the opportunity in the meantime to skim through
Yes,
my friend's submissions.
thank you very much, Mr. Deal. Yes, Mr. Wilson. I did receive your submissions. I have them in front of me. Thank you.
My lady, I'm terribly sorry that I didn't follow procedure. I'm not all that used to the Supreme Court. So I thought that in responding to Ms. Wendy Butterfield, who sent me the email.
Mr. Wilson, you don't have to spend too much time on that. I accept your apology. It's fine. It's not, it's usually something that the registrar would police more than me at this point.
Yes,
I'm
ma'am.
just aware that the proper procedure is to send it to Supreme
Yes,
Court
ma'am.
at gov.em.
I-
But we don't have to waste time on that. You can move on.
Yes, I was apologizing also because I had hoped that you would be able to read the submissions because I didn't want to spend too much time going through them, and rather have you ask questions. But in any event,
Well, I'm very familiar with the issues, so you can just hit the high points and just tell me how the Crown responds to these
so
complaints.
skipping through to ground number one, the Crown would simply respond by saying that there was certainly enough evidence on which the learned magistrate could make a decision. And so we say that ground number one is unmeritorious. Ground number two, which seems to be a more robust point that the appellant is making, we would say that as to the appellant's second round of appeal, the Crown would submit that on a strict literal interpretation, the learned magistrate could perhaps have been faulted for failing to record in her notes or account for the said evidence in her ruling. However, she didn't fail to consider the evidence. It's not that she failed to consider it, it's just that the evidence that the appellant is complaining of doesn't take or didn't take his defense anywhere. And accordingly, that she didn't record it doesn't render the trial itself unsafe. And therefore, we would say
No,
that-
it doesn't, but I think the argument that is being made is the fact that she did not record that as a point for determination suggests that she did not consider it. And that was a point that should have led her to have had sufficient doubt to against the Crown's case.
well, my lady,
Because this comes down to the physical evidence. I think that was the scrape that ran horizontally, and that was physical
Wow.
evidence that the defense, or no, the appellant says was enough to give doubt about the complainant's version, and supports the appellant's version that the complainant was overtaken and trespassing into the westbound lane when the accident occurred.
yes, ma'am. I've dealt with each and every one of the grounds. I've dealt with it rather thoroughly. And it really is a shame that I wasn't able to have the submissions before you.
You're an advocate, Mr. Wilson. You can just spit it off. I understand the facts of the case. You don't, I promise I will read your submissions, but you can just argue it. No, it's fine.
I intend to, my lady. The evidence that is not mentioned by or recorded by the learned magistrate was not at all critical or pivotal to the appellant's case. Because one, it only established that there was a collision, which was never in dispute. Two, the fact that there was a minor dent supports the complainant's evidence. And three, the location of the damage is precisely because the appellant had crossed into the path of the complainant. See, the appellant's case was not that he didn't strike her. It's not, the appellant's case wasn't even that he wasn't in her lane. The appellant admitted to being in the complainant's lane at the time that the accident occurred. At the point of collision, the appellant admitted that, and his evidence was that he was in the complainant's lane.
Mr. Wilson, let me ask you this. Do you accept that there are two contrasting versions as to what happened and how this accident was occurred? On the appellant, then defendant's case, the complainant was overtaking a vehicle which had stopped to allow the appellant to take that turn onto Pine Tree Avenue. On the Crown's case, there was no car or other vehicle in front of the complainant. The complainant had an unobstructed view and access on the eastbound lane when the appellant was taking that right turn. Those are two very contrasting cases. You accept that that was the position at trial.
My lord, my lady, I accept that they are different and there is somewhat of a contrast. I accept that.
One says there was a car in front of the complainant, the other says no, there was not.
Right. But here's the thing. Even if there was or was not a car in play, even if the complainant had been in the westbound lane and had overtaken, that doesn't absolve the then defendant of his culpability, because you see, the point of collision is still in the eastbound lane. And we can get to talking about the scrape. First of all, there are two scrapes. Second of all, the officer that arrived at the scene, PC Butler, she said that she couldn't determine when those scrapes came or what made those scrapes. I can get onto this.
But before you go so fast, Mr. Wilson, I think the point is if I understand the ground that you're addressing, is that the magistrate, the senior magistrate, did not determine that. It doesn't appear from her judgment that she acknowledged that you have these two contrasting versions and that one was supported by this physical evidence. I think that's a complaint. So that physical evidence that would tend to support what the defendant says and put doubt into the Crown's case, that was not a point that she appears to have determined in her judgment. That's a complaint.
Yes, that is a complaint, and I recognize that. That's in their second ground. But the point is, it's not that she didn't consider it. The point is that she didn't record it. And
How do we know that she considered it?
Sorry?
How do we know that she considered that? How do we know that the magistrate addressed her mind to that and that she determined that? The value of that evidence?
My lady, the evidence that the evidence that the appellant complains of not being recorded was evidence that really didn't take his defense anywhere. And so what the respondent would say is, again, it's not that the learned magistrate didn't consider it. Yes, and I will concede that. She may be faulted in the strict literal interpretation of the statute insofar as she should have made, and I'll address this point a little bit more comprehensively later. She can perhaps be faulted that she didn't make a record of the things that she considered. But what we would say is that that evidence didn't take his case anywhere. And so she considered it and she gave it a blanket statement. Her blanket statement, I can't recall exactly where it is right now, but her blanket statement says something like, I've heard all of the evidence. And you see, whilst that's a blanket statement, it makes reference to the fact that she did listen to the defendant when he gave evidence about the script. She did listen to the defendant when he gave evidence about how the complainant was in the westbound lane and then came back into the eastbound lane. What she did was she decided that factually it was inconsistent with the result, which is her ending up underneath the van, which was in the eastbound lane. Now, as to whether or not the learned magistrate should be required, there's case law that says that whilst it would be ideal for the learned magistrate to record each and every little thing, to expect that level of detail, to expect that level of recording would slow the justice system down to pretty much a halt. And so we can't expect the learned magistrate to record all of the things that that come into her consideration. That's how the Crown would respond generally to what's being said in that complaint, that she didn't record it. And so, my lady, in looking at some of the evidence which the which the appellant says was pivotal to their case. For example, the dent. At the very most, the evidence of the dent in the bumper could have been used to challenge the rate of speed at which the complainant said that she was traveling. However, not only was it not challenged by counsel at trial, but the evidence of PC Butler was that there was a small dent, which one might think suggests that it was in keeping with the complainant's evidence that it was not a high-speed collision. Going on to the scrape, what the respondent would say, what the Crown would say, is that that scrape was not caused by that accident. And whilst the Crown at
Sorry, I
trial,
didn't hear that last part. What wasn't caused by the accident?
the scrape.
Oh,
So
the scrape.
my learned friend, Mr. Deal, earlier referred her ladyship to the horizontal scrape, the scrape.
Yes.
And I find it curious, he even refers to the fact that it's going horizontally across the road. That's an indication, my lady, that whatever caused that scrape, it wasn't a bike that slid out, having been in the westbound lane and then coming back into the eastbound lane. It wasn't a bike that, because the trajectory, the proximity, all of that would have been different.
I think the complaint against you is that there was not any evidence, any TCI evidence, and however that should have been analyzed, should have been done by the expert.
Well, PC Butler was the attending officer, and my lady,
My lady, sorry, at the risk of interrupting, my friend has now made the submission twice that well, he's actually made the positive case that the scrape was not caused by the accident. Can my friend show me anywhere in this record where that evidence is put? Because the only evidence that I've found was the evidence that I read to you earlier, where the police sergeant said basically, I don't know. No stage was it ever made, I'll be happy to be corrected, that it was said that that scrape was not caused by the accident. If my friend can point out to me when I'm wrong, I'm happy for him to do so.
Wilson?
there was at no point any evidence that was offered that said that that scrape was caused by the bike sliding, other than what the defense advanced.
The defense have raised it, so it's for the Crown to just prove it as a point, because the burden is on the Crown. That's the argument that you have to meet.
Yes, my lady, and the argument is this: it's commonly known that when a bike is overtaking in traffic and it comes back into the lane from which it left, it's not going to come directly up. It's not going to come horizontally across the center line. It's going,
Mr. Wilson, I don't want for you to try and lure the court into any sort of speculation or any evidence that might have been heard or might have been given. Let's just deal with the evidence that we've had. I'm not going to take judicial notice of any sort of matters that are for an expert analysis, and that evidence wasn't before me. So let's not take that path.
I'm sorry, my lady, that's not what?
Let's not take that path. Just deal with the evidence as it was.
Your worship, sorry, my lady, I'm trying to explain why the learned magistrate would have looked at this evidence and decided that it simply wasn't worth recording it, albeit she had considered it. And in doing so, I'm drawing this court's attention to the trajectory where the collision occurred in the eastbound lane, and the fact, what we would advance as being the scrape not leading to the bike, because indeed the bike wasn't there at the time that the picture was taken. So that is evidence that the learned magistrate had to have considered. And the fact that, as my learned friend refers to the scrape being, it would not have been so perpendicular if the bike, as the appellant says, the bike was coming from the westbound lane into the eastbound lane and slid out. According to his version of events, the scrape would not have been so perpendicular going across the center.
Mr. Wilson, you sound like you're giving expert opinion evidence.
No, my lady, I'm not giving expert opinion evidence, but these as road users in Bermuda, as we all are, we understand the dynamics of how bikes travel. We understand that if a bike slides, I mean, we understand that if a bike is sliding, having overtaken a car, as the appellant says, how is that scrape going to be perpendicular to the center line? So even if the appellant was correct that the complainant was re-entering her lane, the scrape would not have been so perpendicular. It's clear that the angle of the scrape is more perpendicular than it is parallel, which is what would have been seen if the appellant's version was correct. My learned friend, Mr. Deal, said that the learned magistrate was dealing with this case in terms of, more like a civil matter than a criminal matter, insofar as she preferred the evidence of the complainant to the evidence of the appellant. That was totally within her discretion. That was totally within her remit, is to decide that, having heard what he had to say and having heard what the complainant had to say, and looking at the scrape, looking at the evidence, she made that decision, as did arguably PC Butler. When PC Butler arrived at the scene, she took pictures. She spoke to witnesses. She spoke to the defendant as he was there. She spoke to a lady in the ambulance. She came to the conclusion, after seeing a van in the eastbound lane turning onto Pine Tree Lane, after seeing the clear point of impact, that there was no need to call immediately to the scene a TCI. That was her decision. And my learned friend, the appellant may have in his mind what he thinks ought to have happened, but he cannot tell the police how to do their job. And furthermore, it was not even put to PC Butler that she wasn't satisfied with the job that she had done. That was never put to PC Butler in evidence. So how is it now that the appellant is complaining that she hadn't done what she was supposed to have done? So once again, the respondent would say that the learned magistrate did not fail to consider the evidence, though she did not record it in her decision. In a close examination, one can see that the arguments attempted by the appellant at trial with respect to this scrape was simply not worth recording or referencing, because they were fanciful and inconsistent with the actual facts of how the accident transpired.
So where are we now?
Halfway through the response to ground number 2. So at the bottom of paragraph 12, I'll just reiterate that the learned magistrate in this instance used a blanket statement. I have heard all that has been said by the witnesses. This included what was said about the dent and scrape, however unconvincing. While it would be ideal for both sides for the magistrate to list every single factor that went into their final conclusions, to expect that level of detail in every matter would be both impractical and onerous on both magistrates and the court system as a whole. And this was considered by Cameron in a dissenting judgment in Crown against Shepherd. General principle is, and has been for some time, that it is not an error of law per se for a judge or trial judge to fail to give reasons. I just want to skip down to the bottom part of that paragraph.
Yes,
It says trial judges are presumed to know the law with which they work day in and day out. If they state their conclusions in brief compass, and these conclusions are supported by the evidence, the verdict should not be overturned merely because they failed to discuss collateral aspects of the case. And that's what we would submit. The scrape orders, as well as the dent, these were collateral aspects of the case. It was clear that the accident had taken place. The point of impact was in the eastbound lane. And so, my lady, you asked earlier if I would agree that one version of events is different from the other version of events. And yes, that's true. But no matter which version of events you take, i.e., whether there was a car there and the complainant was overtaken, or whether there was no car and the complainant was simply always in her rightful eastbound lane, the fact of the matter is that the point of impact occurred in the eastbound lane. The fact of the matter is the appellant in his own evidence said that his van was rolled back about a foot. The picture is after the van had been rolled back a foot in order for the bike to be taken from underneath, because it was wedged so far underneath the van that they couldn't get to the bike without the van being rolled back. So even after rolling back the van's still in the eastbound lane. So whether she had been in the westbound lane or not, the point is, at the point of impact, that's where she was. She was in her proper lane. So again, the trial would submit that the evidence that was not recorded was irrelevant. When considering the evidence, as it was presented at trial, the learned magistrate did so pursuant to Wilkinson's road traffic offenses, which states, if an explanation other than a fanciful explanation is given by the defendant, it is for the prosecution to disprove. The prosecution didn't have to disprove anything in this case because it was, and this is, I'm not intending to be disrespectful to anyone, certainly not my learned friends, but what was the evidence that came from the appellant was so fanciful that the learned magistrate, while she considered it, she did not feel it necessary to record it because factually it just didn't make sense. It didn't make sense how his version of events didn't make sense. It didn't, and that's why she didn't record it. And that was her discretion.
all right, does that bring us to the third ground of appeal?
Does, yes. Now, I touched on this earlier when I said that the appellant may have had in his mind what he considered to be proper investigation, but he cannot tell the police how to do their job no more than he could have expected that they would have abided by his suggestions at the scene had he offered any. Magistrate Anderson accepted the evidence of PC Butler that she caused an investigation to be made into the accident. And in her evidence, she stated that she had a conversation with the appellant that lasted less than a minute. The duration of PC Butler's conversation is irrelevant. All that matters is that she was satisfied with the information gathered therein. Implicitly, PC Butler was satisfied with the investigation, and it was never put to her that she wasn't or that she ought to have been. She said her rule upon attending the scene was to gather as much evidence as possible. And at page 15, line 5 of the transcript, PC Butler said that she did this by speaking with the defendant, a lady in the ambulance, and the witnesses at the scene. Now, the Crown would submit that in speaking with the defendant, the most salient part of what he said was that he crossed the complainant's path. He said that to her at the scene. Now, whether or not his conversation with her lasted for 14 minutes after that, she had what she needed. She wrote that down. And I do remember my learned friend, Mr. Horseman, challenged her on it. He said, you only wrote down one sentence. Well, that was the only sentence that mattered. Everything else that he said in her decision either was irrelevant, didn't matter, or it wasn't worth writing it down. And that is the fact that he crossed into her path, that is usually the determinant factor of culpability in most road traffic accidents. And from the photos, it was obvious that that's what happened. Accordingly, that is what PC Butler wrote down, the most important part of what the appellant said. And the defendant recalls going into further details for another 14 minutes is ultimately irrelevant. Again.
Yes.
Right. So the appellant submits that the failure of PC Butler to call a qualified traffic collision investigator immediately was an integral part of the defense, and that the London magistrate failed to consider the submission, that therefore there was no proper investigation of the accident. I believe I've already dealt with that, as it was entirely PC Butler's decision. So let's move on to ground 4, which was the evidence of Mr. Stevens' party. Now, the only thing that his evidence, my lady, the only thing that his evidence could do was establish that PC Butler was wrong or incorrect in her estimation of time during which she spoke to the appellant. And the Crown would say that it makes no difference to the underlying issue as to culpability, even assuming that the appellant spoke to her at length, telling her his side of the story. So what? Again, it didn't take his defense anywhere. So the fact that the appellant now complains that the learned magistrate didn't make reference to or include in her decision the fact that he was there to corroborate not the hearsay evidence, but the fact that the conversation took place, doesn't take the defense anywhere.
Well, what the defense is saying is that the learned senior magistrate does not appear to have understood that the relevance of that evidence is that his aversion was not a recent fabrication, but that was something that he explained to the police right from the outset at the time of the accident. So that's the relevance of it. And so that's quite important because it's a case that hinges on credibility and in circumstances where you have one version that competes with the other.
Right. My lady, the learned magistrate dealt with that paragraph.
Yes.
I apologize.
Mhm.
So far,
So Wilson, what is it that you're searching?
I'm sorry?
What are you looking for?
I was looking for a paragraph. I found it. It's at paragraph 17. I thought I had.
17 of the, what are we looking in, the judgment?
I'm sorry, yes, the judgment, my lady. I thought I included it in my submission, but I must have left it out.
Mhm.
Lady, the learned magistrate says in respect of the evidence of Mr. Stevens Carter, he admits that he did not witness the accident, but arrived on the scene after the collision. He also admitted that any information he offered about the collision was from overhearing his colleagues explain what happened. So this, from this, the respondent would submit that the learned magistrate did direct her mind to the evidence of Mr. Stevens Carter. However,
But did she appreciate the relevance of it is what the defense would say? Did she understand that the point of that evidence was that it supported the defense case, that the version that was stated at trial was not recently fabricated, but it was one which was explained to the officer at the scene of the collision, immediately after the collision?
the respondent, sorry, the Crown would say that the learned magistrate took into consideration what she needed to. I hear my lady with respect to what the appellate complains of. However, again, his complaint doesn't take his defense anywhere. And that's because the appellant is saying that the learned magistrate ought to have appreciated what Mr. Stevens Carter was saying in corroborating the story, the version that the defendant gave.
Not the version itself. It wasn't admitted for the truth of its content.
No,
It was just simply to rebut any suggestion that what the defendant had to say was a recent fabrication, that he offered an explanation.
Right.
Mr. Dill, am I correctly putting the position or not? You're on mute, but I see
Yeah,
you.
I'm nodding and trying to, yes, milady. It was 2 points on that. One, to deal with the police officer's evidence that the conversation was just 1 minute long.
Mhm.
But perhaps the more important point is it shows, as your ladyship said, it shows that right after the accident, he gave the version of events that was similar to the version he gave at trial.
Okay.
And we have an independent witness to corroborate that.
To rebut.
And the police officer basically has, well, actually denied the conversation even took place,
Mhm.
which respectfully is, anyway, you have my submissions on that.
Okay.
But
Thank
you're
you.
right, my lady, rebut a recent fabrication. Was the motion.
Yeah, okay, thank you. Yes, Mr. Wilson.
yes, ma'am. So, right. So I thought that you put it correctly, and it seems you have. It still doesn't take the defense, sorry, it doesn't take the defense anywhere. It didn't then, it doesn't now. The learned magistrate acknowledging that the evidence of Mr. Stevens Carter is there to corroborate not necessarily the truth of the version, sorry, of the matter, but the fact that he said it right then at the time. It doesn't take him anywhere, because at the end of the day, he still blurted out and told the officer, hey, listen, I crossed into her path. And so after that, the duration of the conversation was irrelevant. It became a non-factor. It was a non-issue. So no matter what he said and corroborated, okay, yes, this is what he said. He spoke to her for about 14 minutes. And, he was telling her his side of the story. Okay, great. That's wonderful that he was so forthcoming. It doesn't help his defense. It doesn't absolve him of the culpability for causing this accident by crossing into the complainant's path. So again, whilst the learned magistrate might be faulted for not reporting everywhere or every single little thing, I don't think that she should be faulted for that. And I've already directed her ladyship to a passage that deals with that. There are others, I'm sure. she gets it right in the end because PC Butler got it right on the day.
Excuse me, my lady. Maybe please have Mr. Wilson speak a little louder, please.
Oh, is there a problem with it picking up on Court Smart?
Well, I feel it would benefit if his voice was projected a little bit more, but we
Thank you.
can't hear him.
Okay, thank you very much. That's important and helpful. Thank you, Ms. Williams-Grant. Yes, Mr. Wilson.
Thank you. I will speak a little louder. Round number 5,
Yes,
the respondent submits that the learned magistrate fulfilled her legal obligations in accordance with the requirements therein. Because the evidence was not recorded, weren't points for determination as they were irrelevant. The complaint from the appellant is that the learned magistrate did not specifically address the issue of burden of proof, and that she did not give specific reasons as to why she preferred the evidence of Ms. Woods, APS Butler, and over the evidence of the appellant and Mr. Party Stevens. Now, it has long been established that the issues of credibility can be best decided by the court of first instance because, unlike the appellate court, the magistrate had the opportunity to observe firsthand the facial expressions, tone of voice, demeanor, and all of the other things that go into deciding credibility. And there's a case cited, the case of Andrew Robinson and the Commissioner of Police, the Bermuda case, and it's found at tab 9. Respondent submits that in her ruling, the learned magistrate thoroughly summarized both the evidence that had been put forth by the Crown as well as the defense. And you can see pages 12 to 25 of the record of appeal. At paragraph 16, the learned magistrate deals with the items which she found as facts and which form the basis of her final conclusion. And this is where I had the reference to paragraph 17. My lady, moving on to ground 6.
Mhm.
Paragraph 33 of my submission. The starting point is that the Bermuda Court of Appeals case of Formentu indicated that there are in fact 2 elements of good character direction which must be given to a jury. The first limb of the good character direction is that good character should be taken into account when assessing credibility. The second limb is that good character should be taken into account when assessing whether the defendant in question is likely to have a propensity to commit the offense in question. And this excerpt was taken from Sharon Smith of Bermuda Law Reports case 2013. Now in Smith, the court indicated that the main difficulty that it had from the outset with counsel's submissions is that it was not concerned with a jury direction, but with a judgment in the magistrate's court. Now, in Walida Brangman and the Queen, the distinction was that with Smith, the CJ found that the magistrate did not fail to consider the good character issue, whereas in Brangman, the issue was that the learned magistrate was not made aware that the appellant was of previous good character. This is the appellant's most substantial submission, in my opinion. However, the difference between Brangman and this appeal lies in the nature of the offense for which Ms. Brangman was tried. The appellant's case is a traffic matter, and the Crown in no way seeks to trivialize this or suggest that the court ought not to approach the issue of good character in the same manner and using the same formula because it's a lesser offense. On the contrary, the Crown would submit that because it is a traffic offense, its guidance as to the approach of adjudication is much more rigid, but only comes into consideration in relation to sentencing. The Traffic Offences Penalties Act takes into consideration a defendant's propensity to commit offenses as it sets out the respective sentences for each character. That is to say, propensity is specifically addressed where it is a defendant's first, second, or third, or higher offense. The penalty is therefore increasingly becoming more severe. And to balance this, Section 2 of the Act stipulates that where an offender has committed an offense of the same category after 2 years of the date of the first offense, it is treated as his first offense,
Mr. Wilson,
as opposed to his second.
Mr. Wilson,
Yep, no?
what does the Traffic Offenses Penalties Act for first and second and third offenses have anything to do with good character direction when dealing with how to assess the credibility and the propensity issue
Because
on evidence? What relationship could possibly exist between those two?
the Traffic Offenses Penalties Act already takes into consideration how a defendant should be treated with respect to propensity. In deciding, so the appellant is advancing that the learned magistrate made a mistake, or rather should have been, sorry, no, the appellant is advancing that Mr. Horseman made a mistake in not advancing the evidence of good character. What the Crown is saying is that even had he done that, that still wouldn't have taken the case anywhere, because this is not a matter of his good character.
The Traffic Offenses Penalties Act deals with how to penalize someone on a conviction if it is the first, second, or third time or more. We're dealing with how to assess the evidence in an issue where credibility was pretty crucial in the case because there were two contrasting versions between the defense and the Crown.
Yeah.
Listen, I don't want to waste time. I don't want to hear any more about the Traffic Offenses Penalties Act on this point. Okay, I'm not with you on it. I'll tell you flatly on that. I really don't want to waste any more time on it.
Okay. Well, I was going on to say that notably the act does not consider credibility. The respondent would submit that that is because credibility is not something which can apply to accidents. By their nature, accidents are not planned. It is of course congruent that someone who is considered a good driver is less likely to be the cause of an accident. However, that is not what the court is concerned with. That's not what the court is dealing with when it's asked to consider a defendant's good character. Accordingly, the court should not be lulled into equating, associating, or paralleling the appellant's good driving record, if he has such, with his character. Now, historically, the defendant was entitled to adduce evidence of his good character long before the law treated him as a competent witness in his own defense. Such evidence was allowed to be submitted to the jury to induce them to say whether they think it likely that a person with such a character would have committed the offense. Once the defendant became able to give evidence, a further consideration in regard to good character was introduced. And that consideration was encapsulated by Widgery. Now, he says, although there is no formal standard direction in these terms, this court does take the view that possession of a good character is a matter which primarily goes to credibility. And the reason why the court could not concern itself with credibility is because it was not a question as to whether the appellant or any defendant who is of good character, i.e. no previous convictions, could have or is likely to have caused an accident, because anyone, no matter whether their character is good or not, can cause an accident.
That's propensity, not credibility.
My lady, this
The
court,
defense were most primarily concerned with the benefit that the defendant would have had as to the direction on credibility had the magistrate, the senior magistrate, been aware that he was entitled to a good character direction. That's the point.
I'm sorry, I lost you.
Mr. Wilson, please listen to me carefully. I don't want to have to repeat it yet again. The argument and the complaint that is made by the appellant is that in a case where there were two very contrasting versions and the magistrate decided to prefer one or the other, credibility was crucial. And had the magistrate known that the defendant, now appellant, was entitled to a good character direction, especially as it relates to a direction on credibility, that would have been largely to the advantage of the defense and would have certainly rendered the conviction unsafe. That's the argument that you have to meet.
Yes, my lady, and I believe that the Crown is meeting the argument because what we're saying is that the appellant the appellant complaining about there having been no good character direction it would not feature in a case such as this. In my submission, what the appellant is doing is seeking to make the connection between being a person of good character and being a person that is a good driver.
Yes.
And that's a good character. It cannot be confused with a good driving record. It's not the issue. A good character direction would not have changed anything. It wouldn't. The good character direction would have said that the defendant has no previous convictions. He is, for all intents and purposes, an upstanding individual, and so his version of events should be accepted. Because why would he, of good character, commit this offense? But it shouldn't be looked at like that because it's not an offense it's not an offense like other offenses, not an offense like burglary or stealing. This is an offense, this is a traffic matter. And so that's why it's not an issue of whether or not he was a good character. And so the fact that
Wilson, I also want to discourage you from repeating submission that you've made, okay? I have heard you, but please don't be tempted to just start repeating your submissions.
Yes, ma'am.
I'm looking at the time and I do intend to finish this hearing this afternoon. And I would have expected to have finished it by now.
Yes, ma'am.
So by all means, finish your submissions, but don't be lured into just repeating them.
Yes, ma'am.
I think that's it.
You're not on mute, Mr. Deal and Mr.
That's just.
Sorry, that was my fault, minute.
Okay.
In continuing this submission,
Mhm.
the Crown would submit that there is no legal requirement for a jury-style direction on good character to be set out in a judgment delivered by a legally qualified magistrate. That's found at paragraph 13 of Raymond and Rayner. Paragraph 42 of our submission, the Crockle and Miller.
Yes,
Sorry,
yes, you can continue.
yes, ma'am.
You can pick up the pace a little, go on.
Halfway down the paragraph in italics. I think
Yes,
line it says, bearing in mind the appellant's relative youth, the narrow ambit of his defense, and the fact that this type of offense is often committed by persons of previous good character, it was not essential that express mention be made in the judgment that good character had been taken into account in assessing the credibility of the appellant. The Crown would submit that where propensity was not an issue of particular relevance, there could be no legal requirement for the magistrate to make express findings in relation to that issue. Accordingly, I would submit that this ground must fail. Right. So, my lady, that brings me to the conclusion of the Crown's submissions. As I've said, even on the appellant's version of the effect, even the appellant's version of the facts or the whatever, had he been waved on by a car that he says was there, he would still have been the person in the situation that assumed the risk. So, whether or not there was a car, whether or not it was waved on, at the end of the day, the appellant was still found to have been in the eastbound lane at the point of impact. And nothing about this case has been unsafe, unfair. And so the Crown would submit that for those reasons, the appeal should be dismissed.
Thank you, Mr. Wilson. Mr. Dill, do you see it necessary to?
Well, what I think is irrelevant, my lady, respectfully. I think it's if you wish to hear from me, I can make a few, hopefully, very quick points.
Yes.
You, my lady.
To be lengthy, yes.
Sorry, my lady.
I don't think you need to be lengthy, but if there's anything you.
I make a few quick points, my lady.
Yes.
On the issue of good character and the issue of, I think your ladyship has, well, in fact, I know your ladyship has the point of credibility versus propensity.
Mhm.
But if you can just look at paragraph 37 of my friend's submissions, of his new
Yes.
submissions, the last case of V and Wise and Stevenson,
Mhm.
his own authority supports our position. Although there is no formal standard direction in these terms, this court does take the view that possession of a good character is a matter which primarily goes to credibility.
Yes.
So that's out of their own. This business about trying to draw a distinction between the cases. This is a traffic matter, well, my lady. That's a distinction without a difference. It makes no difference whether we're dealing with.
I don't need to hear you on that point.
I'm grateful, lady. And then, yes, just the point my friend made earlier, but he just reinforced it or repeated it again by saying, and I'm paraphrasing, of course, so you forgive me, but it was words to the effect that, well, if even if the appellant's version of events was the correct one, that would still amount to due care. You may remember my friend making those submissions.
I did, yes.
The point being made there, my lady, is
I do remember him making that point, and it's
Yes.
about how the magistrate determined it, really, but go on.
yes, but implicit in that is my friend accepting that that is a viable alternative version of events.
Right.
We keep being dragged, or we have to keep being dragged back to Wilkinson,
Mhm.
because the prosecution had failed utterly to disprove the appellant's version of events.
Mhm.
Therefore, the only way in which they could get around it was if that version of events was, to use the word of Wilkinson, fanciful. That wasn't held by the magistrate. And my friend's, in fact, saying just now, oh, well, that would still amount to due care, accepts by his own submissions that this could have happened. Then the point being made by my friend, who made it a couple of occasions, say that, not each and every little thing needs to be written down by the learned magistrate.
Well, obviously, you say it's not a little thing, it's a determination that's crucial to,
Probably the single most important
Yes.
independent piece of evidence that ought to have been written down. I'm grateful, my lady. And then perhaps finally, two final points. My friend accurately described as the blanket statement in her judgment, I have heard all the evidence.
Mhm.
That doesn't get her. If that got judges out of appeals, all judgments would be about 3 lines long.
Right.
And sorry, then my learned friend didn't deal with the case of Cabral at all. And then finally, the last point, which comes back to this, my original point, when he asked the rhetorical question, how did that scrape get there? And that's the point, my lady, the prosecution don't know.
Yes.
And that's why TCI evidence exists. The fact that the prosecution failed in this case to get TCI evidence is their failing. And there's no reason why the defendant should have to suffer or be prejudiced in his defense of the action because of that failing. Milady, those are my submissions unless I can assist you any further.
Okay. Thank you very much, counsel. I do reserve judgment. You'll have a written judgment, and I don't expect that it will take very long. Thank you.
Thank you very much, milady.
All right. It will likely, I should probably mention, it will likely be sent in the normal way through the registry.
Yes, ma'am.
Is there any particular reason why I would have to pronounce that in an open court proceeding? I don't usually do that, but I'm going to raise it because I know.
And far be it for me to teach you to suck eggs, but I think aren't you obliged to, as this is a criminal appeal?
All right. So what I will likely do is I'll
Sorry, let me
read
be
the judgment if I deem it necessary onto the court record without requiring the attendance of the parties.
I'm grateful, milady.
Okay. All right. Thank you. Hearings
Thank you,
adjourned.
Milady.
Thank you.